sometime last week, we moved an application to have NS Yaokumi convicted and sentenced to prison for his willful disobedience to the orders of the court. You see, the court cannot give his sentence in a vacuum. So the court at this point has found him guilty. That's the meaning of the conviction. When the court says that you are convicted, it means that you are guilty of the offense. Now, because he was not in court, the court now says that he now issues a bench warrant like any other criminal. And the police, the national security should go after him wherever he is and be arrested and brought to him in court for him to be sentenced appropriately.
In terms of the parliament, NPP a minority instead of 88 grand from micro minority, they say the almost a short -1. Nhyira say court ultimately issue a bench warrant. As a yentimen kwachi open your friend say NS Yaokumi awono eko ewo Akwatia NPP dimu yentimen kwachi no na omra me fisi emra. Ubebi say HRC say. Now your videos and timeline of events are itimi ekoko so from 7th of December last year. Edebabesi ene yes see the opening no court etimi awda say yentimen kwankwachi no na yemfanra. Ebutia yensane mu na yenhwe baabi ene free ene de ba bewie ewo eha yenhwa ase. This is a video of an MP ye declare an arrest warrant e de amano eno ntin eventually say witimi free parliament na witimi p na ne okofesi na so twen. Now the chance ene high court e waterkrade etimi issue a bench warrant for the arrest of MP your friend say NS Yaokumi a wono ejina mu ewo Akwatia. Eventually with me ekoi ewo NPP dima sisi with mu ewo parliament na chese NDC for air contest ne legitimacy no ene court issue bench warrant ese yentimi enkoche nemre because wa commit contempt of court and eventually baby obia no apposi for ebetimi ahwehwe no eno na chese few minutes after that court declaration ebusu video we etimi drop ya from parliament who say MP no na hye white na okono okosesa ne niema na wohwe video na obo say kode eja witimi FM ene ye escort ne boko ena witimi epiye na ubisa se efri hin ene besi eha eni ukai video we. Now this is a video by on the 7th of January ebra no mo so in MPs no we MPP MPs no mo protest because the clerk of parliament on the night of the swearing in this man etimi declare say yakai nensa or he is constrained because na we receive court order order ne say anase direct ne say ma ontimi nkoso recognize NS Yaokumi as MP enu ntino ade a MPs ne be bia o parliament no mo entimi emfa ne nka ho ebra clerk of parliament etimi make that declaration no NPP for etimi protest kakra eno na wuhu ewa ha. Now protest way it was a show of force as a boldness ye taye nu enechi ni ade betene ye hu se opening nu APA abusuya ononkwa na ekoboko ya che se eventually se ne ko nsan we ma na se ye che no na ko afia se ononkwa na etimi eko. Now ensem ni nyina e hyase the December 7th elections are so December 7th ukopie ewa Akwatia. The MP's election or parliamentary elections was between this man my friend say NS Yaokumi for NPP and then Henry Yawachi Adom awono nso ejina mu edema NDC. Now after the 7th December elections na bra ye boboye no na chese ukopie mu ewa Akwatia MPs no na opani we ono ejina mu ema MPP no anase NDC my friend say Henry Yawachi Adom no wono etimi enya 17,000 and some coins. All right. Now NS Yaokumi ono nso enie ebra ye boboye na ono nso etimi enya 19,000 ene kakra eguso ebra accounting no ekwo na wie na busia the NDC ene omo lawyers etimi ekopie mu ewo court ewo takrade. Now court omo koye no omo etimi kosiki injunction on 3 parties. Now 3 parties are na involved ewo case we mu enie ewo sa court injunction no 1 NS Yaokumi ya wono na wenya 19,000 anka ye hwa wono mum na anka wene no NDC for no etimi kosiki court injunction eto ne so enyo no nko the clerk of parliament which is openina o make that announcement no e video na mi kire wa na MPP for no e contest no wono so injunction ni bi e kan no now EC wono so injunction e kan wo mu now injunction de na etie ne say NDC led by omo MPV ewa Akwatia etimi contest say election na ekoso ewa Akwatia no processes leading to the declaration of NS Yaukumi as the MP elect no sebi issues ewo ho eno nti court emfa injunctions ento the legitimacy as MP no eso until say ombetimi resolve issues ni nyina awie eno nti court etimi grante that injunction request no the interim injunction etimi eto NS Yaukumi ni election no eso now say injunction order no ebi etimi ekọ parliament enti at the time na clerk of parliament etimi make announcement no omo etimi register MPs no for speaker of parliament elections no na afei na clerk of parliament na etimi anya da order no enti in this video wetimi announce say nensa atai what I say he's constrained and enti no ntimi nkoso and recognize NS Yaukumi a wono age free NPP dim wa Akwatia no omo ntimi nkoso ntoa so recognize no ema na take part of the voting for a speaker of parliament no what I say because injunction abeda wo so so until say injunction ni ebetimi etwa no omo ntimi ema na take part eno na hu say MPP for no esore ye ya no mu ye didi ewo other video no mu now ebra injunction no ekọ no NS Yaukumi enso ene ne lawyers etimi ekọ file the friends stay of proceedings ano mo person ka court no injunction na omo etimi declare the ato no so no ye nkwashi engu eventually eno antimi ankoso omo koso to aso ewo supreme court ruling na omo koye na no omo person supreme court entimi enkwashe the previous ruling na takrade high court etimi aye no what they say na say enka supreme court ekwashe de na enka ho kwan say eventually betimi afre ni MP but supreme court de na ekọ no problem ne say supreme court ruling no entimi ama a definite ruling what they say na say omo entimi ama a conclusive ruling say bia injunction na court no first court ndi atoso ne bia enyina anase ye nkwase but then what went on was that supreme court ni etimi decided say almost suspend the case na anase almost to asheda indefinitely because according to supreme court ruling by then time almost decision na almost they suspended that case and also mutu share that no na the NPP na almost file a motion ama supreme court etimi akwashe the previous court decision no supreme court na etimi e ka say almost entimi am follow due processes eso almost serve NDC for no a part enu nti no omo etimi etu case ni esheda others omo ageni case ni indefinitely so because the supreme court etimi ageni case ni indefinitely no it means say the previous court ruling from Takrade High Court no it is still in force until say supreme court ebetimi ama declaration no that injunction no eda so ensese NS Yaukumi ye friend no say MP anase wetimi 29 AC parliament so yes a committee ade friend say contempt of court what I say even before say court and I say supreme court no ankasa akọ ekosiki a stay of proceedings against the previous court ruling no wetimi eto aso ekopie mu e wo parliament ani wo sori anu adware no akotena parliament of friend ho honorable ya che say wono age aginem say oye MP for Akwatia in the name of MPP wa bra there is a court injunction edane so ebra okopie mu e wo parliament a odi ni djuma eventually openi a friend say Henry Yaboachi Adom no so ne lawyers in the name of NDC omutimi ko Takrade High Court etimi ekobo court amane say ni injunction a wode ato openi a friend say NS Yaukumi so no ase wa violate court order injunction wa violate enti court entimi hwe no wonche na so enti ene ruling na ebae no court etimi tena ase ehwe ehu say ampa openi bi aye friend say NS Yaukumi no ampa wetimi ebu court order so what I say because the Takrade High Court etimi the injunction ato no so all they say wotimi challenge decision no supreme court entimi ma ruling na it means say the Takrade High Court decision no it still stays enti na ese nko twe ne ho ma onko parliament but otwa so ekọ eno ne Takrade High Court etimi atena se issue bench warrant declare no ese wetimi ebu court orders wa committee contempt of court eno nti no aposifo entimi hwehwe na ba bi owu bia no omo ntimi nkodo anmra na ontimi emra me face emra abusuya eno na chese uhu ya chese video bi epie ya openi friend say NS Yaukumi wetimi free parliament na wetimi appear abontin because court ruling and I say there is a court order ye issue a bench warrant ese yenhwehwe no na yendo no emfanmra emefesi court so we any event etimi esi in the case of Akwatia elections abusuya enam so ama ene MPP MP yetimi declare no ese wabu wa committee the friends contempt of court and into court hwehwe no achi no so si anu kopie mu wo court NPP MP se wo honom aka 87 instead of 88 what I say aka 87 instead of 88 opinion say your friend say NS Yaukumi ono nko na sisi ntansa aso ano nti ne pia wo pii se aposifo hunu na based on that bench warrant ni etimi edwa na so wokọ na court etimi ema na sentence ne se ba se onko prison for a contempt of court ono nko na ekọ what I say so say the tie eno no na yanko tie the lawyer for Henry Yawachi Adom the NDC lawyer witimi ejina mu ama ene omunso enya some way somehow is a victory on the part of the NDC yanko tie lawyer no ensam witimi editu dwa over processes etimi e court where the court or the judge had to come up with this decision and eventually issue the a warrant for the arrest of NPP MP friend say Yawkumi ewo Akwatia.
You would recall that sometime last week we moved an application to have NS Yawkumi convicted and sentenced to prison for his willful disobedience to the orders of a court of competent jurisdiction, that's the High Court of the Republic of Ghana. You would also recall that this case has been on since the 31st of December 2024. And the case essentially has been that NS Yawkumi, that's a case that he was not validly elected. We followed up with a motion for interim injunction, which motion was granted for 10 days. Now, on the day that the NS Yawkumi was served with the said order, he filed an application to have it set aside. Now, the court heard the application and on the 6th of January 2025 dismissed it, and thereby insisting that he should not hold himself out as the member of parliament elect. He willfully disobeyed the orders of the court and went straight to parliament and availed himself for him to be sworn in as member of parliament. And he has since then been calling himself out as the member of parliament. We are a country of rules. We decided then to petition the court pursuant and consistent with the rules of court, which is under 50 of CI 47, that he had willfully disobeyed the orders of the court. Now the case was moved, the motion was moved, and it was slated for today for ruling. Today the court, you would notice, you were all in court, that before the court gave his ruling, lawyer Gary Nimaku was on his feet and wanted to be heard, that he had filed some processes and thereby sought to stay the hands of the court from delivering his ruling. The court said, I don't recognize you. And I must say this, it is a bit shocking. And we lawyers don't usually critique one another or each other. I mean, because we have been trained not to. But I'm a bit surprised that Mr. Gary Nimaku would rise in open court in a contempt case, which we all know, we've all been trained and are aware that contempt proceedings are different from, because the standard of proof is even different. It has a different case number. And so what an NSCOMI should have done was to either file an appearance or bring his lawyer to file an appearance. An appearance is done, it's a document that you need to file. Or because it's a quasi-criminal matter, like anybody who has gone to steal a sheep or a fowl, you have to be present in court to purge yourself of the contempt. You don't send a lawyer who has filed nothing. And you would recall that since the inception of this case, Mr. Gary Nimaku has always been coming to court, and he hasn't even filed an appearance consistent with Order 9 of CI 47. And this is serious, but we are waiting, and we will meet him at the Supreme Court. That's a different matter. But you see, today, the court said that I don't recognize you because you are not the contempt, no, you are not an Yawkumi, and you haven't filed anything in this case. So who are you in the matter? So the court said, I won't even record you. And so that is why that arbitration happened, and then Gary had to be in his seat for the court to proceed. Now the ruling happened, and the court essentially saying that indeed all the ingredients in all the authorities he listed proved that he willfully disobeyed the orders of the court, and that irrespective of your opinion about an order of a court, it doesn't give you the license to disobey it until it is set aside. No court, as we speak, has set aside or did set aside the interim injunction, and so he was completely out of order to disobey the orders of the court. And so the court said that when that happens, the law is clear. You need to be convicted and sentenced. And so the court today convicted him. That is, the procedure is that, you see, the court cannot give his sentence in a vacuum. So the court at this point has found him guilty. That's the meaning of the conviction. When the court says that you are convicted, it means that you are guilty of the offense. Now, because he was not in court, the court now says that he now issues a bench warrant like any other criminal. And the police, the national security, should go after him wherever he is and be arrested and brought to him in court for him to be sentenced appropriately. You would also recall that the comment about it. Initially, I wasn't served, neither my client, but the court sought to give the indication, and he said it in open court, the learned trial judge said that it was a letter emanating from the minority caucus of parliament. And you would see the distinction, it's not from the parliament of the republic. Because the parliament is being run by the clerk to parliament and the speaker. The letter didn't emanate from the clerk. It came from their own caucus and said that he could not come to parliament because he was undertaking some serious business. Now the court said he would not even entertain that letter because if he did, it would amount to an inconsistency on his own part because he has ruled that the gentleman cannot hold himself as a member of parliament. So if he's in parliament now and the letter emanates from the parliament and says that he is busy conducting parliamentary duty, the court will not even look at it because the court doesn't even recognize that he's indeed an legitimate elected member of parliament. And so essentially that's what has happened. So as we speak, by close of today, the security forces are going to be alerted that they should arrest Ernest Yaokumi and bring him to the court, the High Court of the Republic of Ghana, for his sentence. It is then that the court would pronounce a sentence on him. But at the moment, he is a convict. The court has duly convicted him, and the conviction essentially means that he has been found guilty of contempt of the High Court of the Republic of Ghana. So that is what.